I want to introduce my co-panelists. To my immediate right is Bob Levine. Bob is the managing director at Bates Compliance, where he draws on nearly 20 years of experience with investment advisors, broker-dealers, trust companies, with respect to compliance, risk management, financial regulation, ethics, and operations. Before that, Bob was at PwC, where he worked with investment companies, broker-dealers, banks, insurance companies, and trust companies to develop compliance and operational processes, as well as to perform specific reviews of these entities around trading activity, supervisory requirements, and annual compliance reviews. Prior to joining PwC, Bob was the Chief Compliance Officer of the Registered Investment Advisor and broker-dealer, in charge of all aspects of compliance, risk management, forensic, and annual testing, and AML. He also worked as a senior examiner at the Boston office of FINRA. To Bob's right is Maria Chambers. Maria began her career in the corporate law department at Cravath, Swaine & Moore, where she supported the corporate, finance, M&A, and international groups. She then joined Morgan Stanley Investment Management, where her responsibilities included overseeing the compliance program for the firm's ultra-high net worth, custom separately managed account and wrap account platforms, and represented compliance and strategic acquisitions of advisors, and managed a team responsible for the North American Compliance Risk Assessment Testing Program and sub-advisor oversight. And Maria was also a vice president and senior compliance officer at Guggenheim Partners Investment Management. And on the other side of the panel is Ian McPheron. Ian oversees a team responsible for all legal and corporate governance matters in the Americas for Aviva Investors. Prior to being at Aviva Investors, Ian was at 14 years at Harris Associates, which is the advisor to the Oakmark funds, where he was interim GC and deputy GC, and he focused on mutual funds, global investment advisory business, and governance issues. And prior to that, Ian had various senior legal and compliance positions with Calamos Advisors and Morgan Stanley Van Kampen Investments, focusing on open-end and closed-end funds and institutional high net worth accounts. I am Michael Koffler, as I said before. I'm a partner at the law firm of Eversheds, Sutherland in New York. I was at the SEC before that in the Division of Investment Management. And I represent all sorts of investment advisors. Some firms are as small as 5-6 folks, and others have 15,000 people and everything in between. Some are insurance affiliated, bank affiliated, insurance company affiliated, investment company affiliated. Others are standalone, and some of the TAMPs, what formerly were called as TAMPs, turnkey asset management providers. So a nice mix on our panel today to talk about vendor due diligence. So we're going to get started here. I have to work the clicker as well, so that's always a dangerous thing. First part is we're going to talk about SEC guidance, and rather than go through the various legal alerts and compliance alerts that the SEC has issued over the last 10 or so years, I'm going to basically just talk about the key themes from all those alerts. I took a look at them and synthesized really the do's and don'ts and the key messages that the OC staff and others have really communicated over the past years. And I just want to go over that very briefly. First theme is that when you hire a vendor, of course, it does not relieve the advisor of its responsibilities under the Advisors Act. You own the results of any vendor that you choose. That's not a surprise to anybody. The key theme, one of the key themes from the SEC staff over the years has been to design and specify standards that the vendors are supposed to comply with, and then actually make sure they comply with the standards you set. Look at your contracts. That's another theme from various legal alerts and compliance alerts from OC. Require vendors by contract to have policies and procedures to detect red flags, to report the red flags, and to mitigate the problems that they discover. Actually oversee and review the compliance programs of your vendors. Require reporting from your vendors on key metrics and evaluate the effectiveness of their reporting. OC has looked at the notices required of vendors by advisors to see what those notices say. Does the vendor notify the advisor of a systems change, an operational change, a key man or key woman change, an acquisition, a new type of software that's going to impact and interact with the advisor software? OC expects advisors, no surprise, to systematically review their policies and procedures on an ongoing basis. They want advisors to look at their disclosures, look at their contracts with clients, look at their contracts with vendors and compare them to each other. Are they all consistent? A new acronym, which I'm going to try to put into the IA industry here, is KYV. Know your vendor. We're all familiar with KYC. Well, OC in examinations has literally asked the question, how much do you know about your vendors? How well do you know them? OC has asked advisors on exams, how familiar are you with the vendor staff that's responsible performing the functions that they are supposed to perform for you? Do you conduct periodic reviews of the vendors and their qualifications and their experiences? So I think KYV is something we should work into our lexicon, because clearly the asset management industry does not have enough acronyms and certainly needs one more. Another thing OC has focused on is, how good of a job do firms do in actually making sure that the vendors do what they're supposed to under the contracts? The staff has, just in the last year, has said, we look at whether the advisor goes back after they did a good job up front of getting terms and contracts and getting stuff in SLAs. Do they test? Do they see whether, the vendor actually did this? No, they didn't do such a good job with that. OC staff said they want to see that when they go into an advisor's shop and look at their books and records. How often, this is a more recent development, focus on conflicts of interest. Not a shock given the interpretive release from last year in June. OC in the last year and a half has said we really want to see advisors monitor for conflicts of interest of their vendors, because that, of course, imposes an obligation then on the advisor to see whether its disclosure is sufficient under Form ADV requirements, and also its disclosure obligations under the fiduciary duty. We just had a panel on cybersecurity. Obviously, privacy has been a huge focus in the last few years. I don't need to beat that drum, but OC has, not surprisingly, again, raised the bar of what they expect advisors to do. They want to see confidentiality agreements. They want to see the advisor monitoring the vendor's access to the information and interaction with the advisor's databases and other systems, and to see whether information is firewalled off where it should be. Another focus in the last year and a half also has been on fees. How good of a job does the advisor do making sure that the fees that are deducted by the vendor or charged by the vendor are what they're supposed to be charged, what the advisor is supposed to pay for, particularly where there's an impact to the client. There have been instances where clients have paid too much because the vendor is charging the advisor too much, which that cost is then passed on to the advisor indirectly. Business continuity plans, which has been a focus of everyone in this room, I guess, the last couple of weeks, especially for critical vendor relationships, whether we're talking about brokerage, custody, clearing, settlement, trade support, et cetera. OC has in the last year and a half said we want to see whether vendors, do the vendors provide critical services? Do they have BCP plans that actually are worth anything? And how well is the advisor looking at those BCP plans? So again, KYD. OC is now really expected, and has for some time, frankly, advisors to categorize the vendors into low risk, medium risk, high risk, or whatever category you think is appropriate. And this came up in the last year in one of the compliance alerts, where they said, advisors have to really explain to us how they determine what the appropriate level of due diligence is. And if you don't assess your vendors, you can't do that. So it's really by necessity that you have to do that. There's a whole compliance alert about cybersecurity. Let's just say that advisors are now expected to do risk assessments of their vendors with respect to, again, their access to the advisor's networks, and to incorporate those requirements into your contracts with vendors. And here's one which is really interesting to me, at least, which is to provide information security training to vendors that have critical access to your systems. One thing that comes through, it's not really in words, but you see it in a lot of different ways, is what I call don't put all of your eggs up front, which is a tendency of certain advisors to focus their resources primarily on vendor selection and not as much on ongoing monitoring and due diligence on an ongoing basis. And too many times you see firms rely on stale assessments where the world has changed, the technology has changed, the conflicts have changed, the systems have changed. So I think firms would do well to keep in mind the Japanese concept of Kaizen, hopefully I'm not mispronouncing that, which translates into continuous improvement. It's certainly not one and done, and while it's understandable to have a large resource allocation up front, you really need to be sensitive to what has changed and make sure that 3 years later, your risk profile of the vendor hasn't really significantly changed. And that's something that OC has stressed in the last year in some of their risk alerts is ongoing testing. Contingency plans, again, part of that is BCP, part of that is, well, what if the vendor just goes bankrupt? What are you going to do tomorrow? And that's something that, again, in one of the more recent compliance alerts, OC has stressed. And then a couple of final things which should be kind of no-brainers, which is do what you say you're going to do. There have been enforcement actions, which I should mention. There's an outline, detailed outline, which talks about everything I just mentioned and goes into some of the enforcement cases and has a suggested due diligence checklist and a suggested template for a due diligence process. In one of the cases is the advisor said we do X, Y, and Z, and of course they didn't do X, Y, and Z, and so that was an enforcement action, so that shouldn't be a surprise. And then the last kind of thing that I took from looking at the last almost 15 years of guidance from all these alerts is have procedures not just for hiring vendors and monitoring them but also terminating them. What's your criteria? What are your criteria for terminating a vendor, and what are your criteria? How are you going to handle presumably there's going to be someone else, unless you take it in-house, of course. How do you transition that to someone else? So that's something that OC has started to look at recently as well. So those are the takeaways. That's 15 years of guidance kind of in a few minutes. I thought that was a better approach in saying here's what OC said in this legal alert versus that legal alert. So that's kind of setting the table in terms of expectations from the SEC. In terms of overall approach, I'm going to turn it over to Ian, who's going to start us with this conversation, and particularly with respect to governance structure.
Sure, thank you. The firm's due diligence framework must be tailored to the resources that are available to the firm. That's kind of a no-brainer, but people forget, and I think sometimes OC forgets, there's really small guys and there's really big guys, so no one framework works really well. But what it does have to do, it has to be robust, it has to be flexible, to be able to identify and address the risk presented by a variety of different vendors. Again, people struggle with this, even large firms, because they don't want to be overly difficult to onboard a new vendor, and they don't want to be too soft either. However, when you're building out your governance structure, there are at least 4 attributes that each framework will have. The first is accountability. Who's actually going to do the due diligence? Who's performing those tasks? Generally speaking, the due diligence is done by a team of people. The framework will also indicate who the executive is in charge of the overall due diligence process. That's usually the COO or an executive committee. The second attribute is approach. Typically, vendor due diligence utilizes an integrated, multidisciplined approach involving members from key functional areas. Obviously, the impacted business unit's going to be involved, and then risk, compliance, and legal. The governance framework must be flexible enough to allow for different levels of due diligence to be performed by different folks based on the risk assessments done by those key functional areas. Various tools are used to do due diligence, right? You have third-party assessments, questionnaires, interviews, on-site visits, and reference checks. Obviously, the more critical and high risk, the more due diligence you're going to do on a particular individual or on a critical vendor. The third attribute is timing. Obviously, each vendor will go through their initial due diligence, but further due diligence is going to be driven by your risk assessment. Some highly critical vendors, there's a daily scorecard I've seen of really highly critical vendors that'll give you how they're performing on any given day, almost any hour. You can check on those vendors. Others you may take a look at every 3 years or so, like the coffee vendor, for instance. The final attribute.
I disagree. I think that's absolutely good.
You didn't get up at 4 o'clock. The final attribute is documentation. Generally, there's 3 categories of documentation you want to pay attention to. The first is the due diligence program itself and any amendments that you have to it. So you want to keep iterations of that program. The other is the materials and processes that you use to do your due diligence. kind of examples, both initial and ongoing. Examples of those, again, are scorecards, risk matrices, internal control documents. I'm going to go through a list, so bear with me. Regulatory forms, financial reports, business continuity plans, security audits, compliance policies and procedures, and background checks on key vendor individuals, executives and those key men or women personnel. That's just kind of the tip of the iceberg of very generic documents for what you're doing for the ongoing and initial. The last category is how you document your conclusions and what you do based on those conclusions. If there's something wrong that you need to remediate, you'll need to document that. That's usually in a finding report that the due diligence team does. And oftentimes there's a summarization report that'll go to your CEO, COO, or the executive committee. Although all these underlying documents will vary depending on who you are as a firm and what your vendors are, those categories should hold for any size firm. I think I hit all of those. So I think next slide.
So the assessment of vendors, and Ian, you really touched on a lot there, and I think some of the things you just said actually really respond to this slide as well, how to assess. I just want to pick up on a few themes, Ian, that you mentioned, which is flexibility based on where the risk is. And, it's very common to have questionnaires. One of the things I've seen firms do is, okay, we have a questionnaire, and they kind of use it for different types of vendors. They don't really tailor the questionnaire to, the coffee vendor versus, your trading software or your, CRM. So I think that is critical in really taking, you might have a base questionnaire, but really tailoring it to the particular vendor you're talking about. And when it comes to, things like, cybersecurity, we have to be, things are so specific now. What where are the servers? Like you might have different, where the server is located. You might have different standards and different criteria if the vendor's in California because of the CCPA, or is subject to the GDPR, or Massachusetts. So you can see how it's just, the same activity with two different vendors, but they're located in different states, can have different impacts. So you see how the key for flexibility and tailoring is just so crucial. I'll just mention that the outline does again have a discussion of how to actually, a template process to how to conduct due diligence, and again a draft questionnaire which does need to be really tailored. And Ian, one thing I want to come back to is the critical vendors. Can you talk a little bit about what might be different for those vendors?
Sure. The critical vendors are those that you cannot live without. Those are the vendors that you need to meet client demands on a daily basis. Usually there's 4 or 5 of them in the typical advisory relationship. Your trade order management system, your portfolio management system, your research system, your CRM system, and your client accounting system. These vendors will drive your most extensive due diligence inquiries, not only from a performance and functionality, but again, as to cybersecurity and business continuity, because obviously you need them to do your job on a daily basis. So those critical vendors are going to be placed as we get to risk assessment. Those are going to be at the top of your list.
Okay. And you just mentioned risk assessment. So Bob, let me ask you, I mentioned risk matrix very briefly. What do you recommend firms do with a risk matrix? What's kind of best practice there?
Well, first, I think the best practice is really to make sure you have one. I would be very surprised if everybody in this room could honestly raise their hand and say that they're taking all of their vendor risk assessments and placing them into a matrix that you can take a look at. It's very helpful for a number of reasons, but more than anything, it's a snapshot into what you can do, what you should be doing, what your governance structure should be looking at, how compliance and IT and operations should be looking at your different vendors. Clearly, there's different risks involved, and they're going to be unique towards your firm, but you want to make sure that you're identifying those that have the greatest reputational impact, financial impact to your clients. If they have an opportunity to lose sensitive data, there's going to be a big difference between how you treat the coffee vendor versus how you treat someone that has your CRM information and a lot of details about your client base in there and how that's backed up. So it will give you a snapshot into how you will now go about doing your continuous monitoring of your vendors, and how often you should be doing it, what those should look like. Again, if you have a firm that comes in and does some sort of coaching for you or does a brand assessment for you, you're not going to probably go out and do an on-site review every 2 or 3 years of them versus someone that's backing up your sensitive information, that's carrying your books and records, that has material non-public information or personally identifiable information where there may be a process that you can identify off of this to go out and take a look at these vendors in a deeper way.
Okay. And I guess for everybody, what about initial assessments versus periodic assessments? What do you think? How do you think firms should be thinking about that? What's different for a periodic assessment other than typically it's less than the initial assessment?
Yeah, I think it's just what you said, right? It's a little bit of a shortened, lighter touch version than what the initial assessment is. Your initial assessment is going to look at operational service impact, cost to the firm. You're going to want to make sure that they're complying with regulatory requirements, but you're going to ask a lot of questions around the finances of the firm. Do they do penetration testing? Have they had any data breaches? Which is all really good for that first review. But you can't let it sleep on it. It's just like any other compliance program. We've probably all heard it 1,000 times, right? It's a living document. Make sure you're testing it. Make sure you're monitoring it. I would stress that with your vendor risk program, which is continuous monitoring of your vendors. Again, taking a risk-based approach so you're not spending 60 hours a week looking at non-material vendors. However, you want to make sure that your vendors don't have some sort of financial change, or if you have a certain team that is servicing you in your initial assessment, you've asked what the tenure of that team is and what the breadth and experience of that team is, especially if it's an IT vendor, and now all of a sudden 2 years later that team is totally turned over. Well, you haven't updated your risk score now, and if that's a significant part of how you go about looking at your risk, you've got to update it now because it may mean going back out and doing another on-site or having a conversation with that vendor.
All right. Anything else before we go on to the next slide? All right. So the next topic here is assessment of vendor review and approval process. And we're going to turn it over here to Maria to lead this slide.
So the annual review process. Typically, the annual review process at my shop is conducted on an ongoing basis. It's not at one point in time. I lead it, but at the same time, I engage subject matter experts across the board to help me do that throughout the year. So if it's looking at our IT provider, I will have my IT team there, the information and cybersecurity risk officer, operational risk officers, and because cybersecurity is such a unique language, that is the one area where I actually feel it's important to source experts in the area. So I've actually engaged a cybersecurity firm to kick the tires, test our systems, give us a report of our weaknesses, rank them across the board, and then work throughout the year to close the gaps, to do phish testing, to do penetration testing, all things that I think you really need folks who know the language to come and speak to that. And similarly, I think that's an important approach as it pertains to the training as well. We typically document issues and make sure the senior management is aware and then remediate pretty much the way we would approach the annual review across all the functional areas and processes of the compliance program.
Let me ask you this question, Maria. It's a question I get asked all the time, and there's not really a quote great answer or best answer for this question, but it does come up now with an increasing focus on cybersecurity in particular, which is how do you know when how do you internally feel good? Okay, you know what? We are where we should be, or where we need to be, or are we comfortable? How do you make the decision? I think we need to do more testing. I'm not feeling great here. How do you make that decision? We've done enough here. We're at a stage where I can go home and sleep well tonight. Okay, Maria doesn't sleep well tonight.
I don't sleep very well
as soon
as it
you start
pertains to
thinking you've got everything
cybersecurity.
figured out, that's when you stop sleeping.
I do listen to what the regulators are saying, which is, and I think we can borrow from the title of this panel, which is one approach does not fit all. I think that applies not just to the firm that I work in or the amount of resources that I have to throw at this problem, but also with regard to the vendors themselves. And so with that in mind, I always feel that we need to be flexible. We know that they want us to do our best efforts. We know they want us to have a cybersecurity policies and procedures, a program. We know they want us to fish test. We know they want us to do training and to do pen testing. A wish list item, I would love to have real-time monitoring by experts that are, constantly trying to see how we're structured and what vulnerabilities we have. But again, it's risk-based, and also there's resource constraints depending on the size of the firm. And so we're constantly feeling nervous about it, and we always feel like we could be doing more, and I think we can. But at the same time, I think we're all struggling with the same problem. And I also take a look at the fact that you have large firms that have dedicated teams focusing just on cybersecurity. They get hacked, they get ransomwares, they get fish scammed. And so I think that's how I sleep at night, knowing that I'm throwing efforts, that I'm keeping our employees sensitized to the issues, and that we're doing the best that we can.
I think, going back to my CCO days, it comes back to everything else we've always talked about, right? Is your approach reasonably designed to detect, to prevent the risks that are associated with your vendor from popping up? And I think especially for the 90% who don't have, enormous risk staffs and IT people to help with this, making sure that you're changing your approach. So the last thing you want to do is go in and test your risk program, your vendor assessment program, the same way every single year and get blinders on, because now you become the risk of missing something because you're looking at the same handful of things every single year. So it's having other people, whether it's in your enterprise or outside of your enterprise, coming in to help you with that, just to get a fresh set of eyes on it.
I agree with both of you. I mean, the words of Gene Kokie resonate with me. For those of you who haven't been in the industry long enough to know Gene. Gene was an associate director in OC when the compliance rule was adopted. And he, by the way, I should mention the SEC website and the OC part still has some of the best material from, the mid-2000s from Gene Kokie and Lori Richards, which is still, it's still on the website. It's still great for everything we're talking about, and it still is as valid today as it was back then. One of the things he has really emphasized at conferences like this is, look, first off, we don't expect anyone to be perfect, and we frankly get kind of concerned if we go into a shop and they say, oh, we're all good. No, that's when we really get scared. And I think a firm should be scared if they think, if they're not scared. What he said is, it's about process. And I think, Bob, you hit it on the nail on the head, reasonably designed. What they really care more than anything else is how hard is the firm trying to, number one, seek out issues, and number two, rectify them. And if they're doing that on a constant basis, yes, from time to time they may miss something. But OC's not really going to be concerned about that. What they're going to be concerned is if they're not making the effort or the effort is not reasonably designed. So just to help people sleep better tonight, I would just emphasize those words, because those words have really stayed with me all these years. And even with the current senior staff of OC, that view has never changed once in the last 20 years. Even from when I left the commission, that has been the view then, it's the view today. So hopefully that will make people.
Well, there's a little something about the reasonably designed component, how we can set our trap for ourselves, and that we should loosen the noose in a way, because the moment that you determine that your policies and procedures are reasonably designed, and then you go ahead and have a series of exceptions to what you say you need to do or need to have, then you're setting yourself up to have issues, during an exam, because you're basically saying that the policies and procedures that I reasonably designed to protect the firm, I'm not going to follow.
It's like Dahlia Blast said this morning, if the FAQ is for the custody rule longer than the custody rule, you know you have an issue. If you have more exceptions than you have the rule itself, you probably also have an issue as well. All right, so what we thought we'd do at this point is talk through some case studies. So we've talked a lot about principles and rules and ideas. We want to talk now to really how that gets implemented in practice. So the first case study we're going to talk about is a vendor that's providing a software solution. And we want to contrast what might be done for that type of vendor versus what approach might be taken for two other types of vendors. So starting with vendor as software, Bob, what comes to mind in terms of strategies for due diligence?
Depending, of course, on the software that you're talking about, we're assuming that this is a higher risk software program and vendor that you're bringing in. So you want to really have a very long conversation with the team at that software, and I would probably go outside of their business development person and have a conversation with the people that really know that program inside and out. And also not just the program, but the business as well, because we've all been there where, you know, you have a certain software and trying to migrate it over to something else is going to be a nightmare. So if this is going to be your decision, you want it to be the longer term. So you want to find out, you know, obviously your basics. How are their encryption standards? What do they have password management? You know, what their internal policies are, but also in terms of what types of acquisitions they've done, what kind of risks are they bringing into their organization through these acquisitions, and what the due diligence they did on those other firms have been. Is also their encryption standards, their security policy, business continuity plan, but also you know, find out what those plans are for new releases, how they're going about doing breach sourcing, breach testing on their side to make sure that if you're using a software that's, say, cloud-based or internet-based, that it's not going to become a portal into your area. Again, finding out what the level of expertise are on the team that developed the software, that's servicing your software, that's going to be working with you, how often they're monitoring on their side as well.
And Maria, who should be involved in that process, and how should risk be assessed?
Sure. So I think it takes a team, and if you take nothing back from me, I think that's the most important thing that I want to share, because and it's been proven out and supported by the SEC. So an example would be, I think there was once upon a time when, after you hired a vendor, all of a sudden the oversight, the annual oversight, became an annual thing done by compliance. That is not enough. So I think the important thing that I've driven in my firm as an example, and getting the support of senior management along those lines is super important, is that a vendor relationship needs to be owned by the business. Whether it's software, whether it's people, or whether you're outsourcing an entire function, you need to identify who's the subject matter expert that should be owning that relationship. I've seen firms that have policies and procedures where on the side they'll have a chart setting out all their vendors and assigning responsibility. And that person is responsible to be on the initial, ongoing, and annual due diligence, manages the relationship, and then compliance provides a layer. So the team is usually compliance, it's legal, it's information technology, specifically with respect to software. I like to assess the risk of software vendors by putting them in two buckets. Do they interact with my systems, and do they have any access to my client, employee, or intellectual property? The moment that they do, they go into my high-risk bucket, and everything else goes into another bucket. And then from there, obviously, you expand what you would expect and require from a vendor. So, for example, if they are going to have access to my network and have the potential to access my client or my firm information, I would insist that they sign a confidentiality agreement, not so much if they're not touching my systems. And yeah, that's, I think, in a very high level, what I do when it comes to software.
Okay. And Ian, what about when it comes to contractual provisions? What might firms, what should they be thinking about?
There's lots of contract provisions you can put in. Speaking as a lawyer who has to review a lot of these things, I think a couple stand out to me. One is data ownership. Who owns the data? Do they own the data? Do you own the data? Obviously, SLAs in the software are important. Also, renewals and termination. Those are critical so you understand when the renewals will come up and when the termination provisions will come up. And then another one is data breach. You're going to assume something's going to get breached in the data that they have, because usually data that now is not stored in one spot, it's in the cloud. You figure there's going to be at some point a data breach. So from a contractual standpoint, to the extent you can get this, you want provisions that deal with notification, that deal with remediation, and that deal with liability. If you can get those three things, you're doing a pretty good job up front for your protections. You want notification provisions, as you've said. If there's large changes in the overall software, they're going to do a large update, and they do it Wednesday at 2 o'clock. That doesn't work. You need to know when they're going to do updates. And then just two more price increases, especially for software. I always find this annoying for software, that they have these kind of built-in upgrades to their price. Generally, I always think software should go down in price over time, not up. So try to put a limit on your price increases, or tie it to something that's observable, like CPI or something like that. And then finally, try to have a contract resolution provision.
Great, and that's great. And just, there was a question?
When a smallish firm is dealing with the giant provider of software, they
Yep.
negotiate the contract terms?
Some do, depending on what the issue is. If you're dealing with Bloomberg, probably not. Having dealt with Bloomberg, they will not change anything, but it will depend on what they do. Sometimes they do have very vendor-friendly terms. Then you're just stuck with them. That's the risk that you have to take on, and they'll be the more difficult ones to do due diligence on too, because they won't share information with you, and those are risks that are presented to each one of us, no matter what your size is. I've been in big shops, small shops, and some of those really critical vendors like Bloomberg and others, you're kind of stuck with what they have. But it's important for you at least to identify what their risks are and what they're presented. So when the SEC comes, you just don't go, I did the best, I didn't do anything, okay. But you have to at least try to document what your risks are and risk rate them, depending on what Bloomberg does for you.
That's a great question, and I think that's a great answer. I mean, the reality is there are going to be times where it's a take it or leave it, and you just have to assess that. I mean, and one way to assess that potentially is if they're a big player, chances are there's a good likelihood that their product has been used in the industry for a long period of time, and there are others that you might be able to call up and say, okay, how's the vendor, how's their system work, so you can really get to deal with that through other firms that have had that have used that software for a period of time. We've all heard horror stories how the vendor promises the world on day one, and then once you sign the contract, you try to call them, they're not there. You try to get them to address an issue. There's, the response time is, not, So I think on those sorts of things, which is does happen, is speak to other firms that look like you and see what their experience is with the vendor.
The other thing I'd mention on that, a lot of the big firms, like big vendors, they're getting asked the same questions over and over from all of us. So rather than answer all of our questions individually, they'll often have kind of stocked questions or answers that they'll give you. They'll give you their security audits. They'll give you the third-party assessments, their SOC ones. So they don't want to answer your questions individually. They understand your kind of predicament. So from a due diligence standpoint, I think that's probably the route most of them go.
That's a great point. I think that's a relatively recent development because one of the things that the OC alerts have done is made it easier for advisors to go to their vendors and ask for this stuff, saying, look, our regulator is demanding this. Here are the questions I asked. If you don't answer us, we can't use you. So I think that's starting to help with the information. The old S70 now Type 2 reports are SAA E16s, and you're starting to get Right,
two,
type 2, you're
3,
starting to get
type 4
more.
diabetes. I don't know.
Yeah, you're
There's a
starting
lot.
to get more information from these vendors where you never got information in the past.
It's interesting. So as the vendor on the panel here, we do a lot of things from consulting and outsourcing, but we do data analytics and big data, and we do transaction monitoring, things like that. So in the past 2 years, we have seen a significant up-ramp in the amount of firms that are coming to us as a vendor and doing initial assessments, looking for SOC reports, doing ongoing due diligence. It's made us wholly change some of the processes and technology we've had internally too in a much better way, made us a stronger firm. But if you're not looking at your vendors, whether it's not, we talk about vendor risk management, we're not talking just, the big client-facing information, it's anything you have. You should be really thinking about going out there and making sure they're going through a whole lot, jumping through a whole lot of hoops for you to protect your data, to protect your integrity and your reputation as well.
And one I would add to that is law firms. For your vendors, make sure you're doing a good due diligence on their systems and software that you're transacting with them, because oftentimes the most sensitive data you have in your firm is going to your law firm. And make sure their systems from mostly a cybersecurity and communication transfer is top-notch. That's a relatively recent thing, probably in the last 5 years or so. But I know my firm's pushed it, my old firms have pushed it. So pay attention to that as well.
Yeah, no, the world has changed for us and for most firms in the last year. We have ISO certifications now in my firm that, people didn't know what that was, before, 2 years ago. Now we have annual and semi-annual tests, people coming to my office and looking at all sorts. The world has changed. There was a question right here in front.
Yeah, sure. Ian kind of addressed my question.
Sure.
Before we answer, I just want to repeat the question so that everyone in the audience heard. The question is, when you get something like a SOC 1 that's 800 pages long, written in IT speak, what do you do with it? How do you assess it? What are you supposed to make of it?
Well, reviewing the SOC 1s has been a lot of the work that I did over my career when I was assessing supervisory and service provider oversight, but it was a shared process. So to your point, my IT person, my chief information officer person, my cyber person, they read it too. So it's, again, a team effort, because we do know what to look for, and collectively we can make a decision if there's anything that is a red flag that would then require some form of follow-up with the vendor, or alternatively, most of the time, it's okay. But that, I do think it needs to be shared.
Yeah, I completely agree. If we were to get something like that, the first thing I do is I give it to my IT person and ask them to translate it to English for me. But then also we'll go to operations, and we would have had a gathering about, what's important to each one of us and what the data is that we're actually looking for, because even though we give it to IT, IT is going to look at it from a very specific lens, where I'm probably looking at it from something different. Ops, finance are all going to look at it differently. And then it's pulling out the relevant data and asking the questions on a follow-up or a series of follow-up conversations with the vendor.
And I tend to look at it more holistically. I do rely on everybody else because I'm not an expert in a lot of the IT stuff, but I do look at the reputation of the firm that actually did the SOC 1. If it's a small firm on a critical vendor, I'm probably not going to pay attention to it. It's not going to be very valuable to me. I'm going to look at the actual conclusions at the back. So yeah, it's 800 pages, but in the back, that's where all your, did they satisfy it? Did they remediate it? What's the issues? And then I'll focus in on those that didn't pass. So, if one of the big four is doing the SOC, I'm probably going to have a lot better, feel for that than I am some two-firm place down in Florida. I'm just not going to feel comfortable with that. And I will go through again the questionnaire route.
And potentially that might be enough if you're comparing that vendor versus others. That might be enough for the vendor to be off of your list.
We actually had a vendor switch their SOC provider, and it was one of our internal accounting folks, and we stopped. We refused to use them anymore. We terminated the contract because they went to an auditor that was a two-person firm, and we're like, what? You're handling all of our employees' cash flow from their payments to their expense reports. They're like, no, that's not going to work, and they couldn't explain why they switched, so we terminated them.
I'm an auditor that actually does SOC audits, and I can tell you I'm with a smaller firm, and I can guarantee you our
suggesting I'm not suggesting they couldn't do a good job if they're small, if they have a good reputation of doing it and it makes sense. That's just from a legal perspective. I'm just looking at that really quickly to decide how I'm going to view it. That doesn't mean it's not valuable.
Well, I just don't want people.
Yeah, absolutely, absolutely.
I mean, because our firm does a lot of these.
Yeah.
And we do a good job, and I've picked up many a client from PwC because they weren't satisfied with the work that they did. So, I mean, that's kind of a little bit skewed. I'll also say that another thing is that a SOC 1 audit is not an IT-based audit. It is about controls. And so while IT may be able to help you with that in some areas, a lot of that is operational controls, not IT focused. The SOC 2 is going to be more IT focused, but not the SOC 1.
Agreed.
And the other thing that's very important that you also need to point out is that there are user control considerations within that report that says these are the things that the user should be doing, and it's very important to map that to what your controls actually are,
Right.
so that you can rely on their controls based on the controls that you have in-house.
And real quick to your earlier point, though, and it ties back to something we had said earlier, too, is when you're doing your assessment, whether, so you're a SOC audit firm, right, whether you're PwC or your firm, it doesn't matter, take a look at the team that's going to be doing the audit, right? So while there's a lot of weight that goes behind some of these big four banners, right, make sure that the team that you're using and seeing their CVs and their experience is part of your assessment of that organization. Because let's be honest, you're going to do a vendor risk assessment on your SOC auditor as well. You should be. So that would be part of it too. So to your point, if it's, Joe and Mary's CPA down the street, that's going to be a little bit different than your firm or PwC or E&Y or whoever else.
And that's just one part of your overall assessment, right? That's just one part. You're going to check references of your vendors. You're going to do other due diligence around them. Third-party assessments are important, but they're just one tool that you're going to be using.
Given where we are with time, why don't, just a high level, I'll open it up to the whole panel. Can you talk about what might change if the vendor is not a software provider, but is, let's say, a consultant that's providing services that are outsourced?
I think from my perspective, the people that are coming into your office, it really goes to your point of what access do they have to your information? What are they doing? Who are they dealing with on a day-to-day basis? So I would focus in the same sort of risk that you're looking at for anything. It's what do they have access to and what are they doing?
Right, and if it's people that we're outsourcing, and for the most part, if it's a service provider, a sub-advisor, GIPS verifier, you really are amping up the due diligence. So it's pretty much you're following the same script. You're just requesting likely more documents and having broader teams involved. So I wasn't meaning to suggest that, for example, reading the SOC 2 is something that is done between compliance and IT. I think the question was pretty specific to IT, but really you have operations weighing in because you're testing a host of controls across your organization, which all give you a sense of comfort and security with regard to your vendor. The questionnaires, whether they be initial or annual or ongoing, I think tend to be more robust. I feel that when we're talking about vendors that are people, you need to really amp up the program, and whatever you want to get out of the relationships in terms of initial, ongoing, and annual, it has to be established up front when you have a lot more leverage. And the clearer you are as to what it would take for you to feel that you can implement a successful oversight program, the more you can put in the table at the upfront and get buy-in so that the service provider is not shocked later on when you start throwing things piecemeal at them. The framework is established effectively upfront. And another thing that I think is really important not to lose is the ongoing communications that the subject matter expert or the end user of the provider has. Sometimes, you think due diligence and you think, oh, it's a questionnaire, it's initial, it's annual. It's ongoing. through the reports that they generate, through the service that they provide, the conference calls that you have with some frequency, whether they're weekly, monthly, daily, that's all part of the due diligence process. It's not just an initial or an annual thing.
And real quickly for me, it really depends on if you're outsourcing functions to people, it's what are they doing for you. There's probably some sort of machine behind them at some point, so it's asking them the questions about their processes and the technology and the solutions that they have that are driving their machine, the same way you would ask those questions if it was in-house at your place.
Why don't we finish up on this slide, which are the takeaways, and I'll just load it up for everyone. What are the do's and don'ts? What are the lessons that folks should take away here? What should people be thinking about going forward? What are the biggest challenges?
For mine, it would be don't sleep on it, right? Just keep continuously looking at your vendors, keep continuously assessing their risk, asking the questions. This is a lot of times this is a little bit bigger than a bread box, and I know I'm the one that said reasonably designed, but that doesn't make you sleep at night when it comes to your reputation as an organization, and a lot of times that's the biggest risk with the vendors that you're using is what kind of reputational risk hits you if there's a breakdown. So continuously march through your process, refine your process, and keep looking at your vendors.
I would say policies and procedures that are achievable and well documented and can be tested.
There's a couple. One, outsourcing is going to increase over time. Fee pressure and fee compression is going to make you outsource more. So make sure you have, as we've all talked about, make sure you have the right people in place up front doing your risk assessment, because you can't possibly hope to build the right contractual provisions or due diligence process initially or ongoing without a really fundamental understanding of the risk that vendor presents to you. And no one in any organization can do all of it for every vendor. So you need to make sure you have your IT people there, the business people who are going to utilize that outsourced service, risk, compliance, and legal.
And I guess we'll close with that point, Ian. It's probably worth mentioning that OC agrees with you, because they said in the 2020 examination priorities letter that came out a couple of months ago that they are seeing advisors outsource more than ever in the past, and they kind of hinted that they expect that to continue. So, and they also mentioned that that's going to cause OC to focus more on this in the future. So life does not get easier for any of us in the future. Thank you all. Appreciate the questions. They were fantastic. Thank you.